It's time again for the Throttle Up Leadership Podcast with Dr. John Dentico. Our podcast challenges the traditional ideas of leadership and aims to provide distinctive perspectives, knowledge, and practices for building leadership capacity to meet the emerging trials of a volatile and uncertain future. Are you doing enough to protect your intellectual rights in this digital age? Do you know the legal difference between a trademark and copyright and the protections they offer? What are the implications of artificial intelligence on the digital rights of each content creator? If any of these topics interest or puzzle you, then I am confident my conversation with attorney Karin Coger, founder of the Karin Coger Law Firm, will be informative and illuminating. So let's get started. And if you enjoy our podcast, please like, share, and subscribe. We genuinely appreciate your support. Hello again, and welcome to the Throttle Up Leadership Podcast. I'm your host, Dr. John Dentico. Today, my guest is Karin Coger, Esquire. Karin is the founding attorney of the Karin Coger Law Firm, a boutique legal firm specializing in intellectual property. The Karin Coger Law Firm specializes in the areas of trademarks, copyrights, and contracts, offering essential legal services to assist businesses and creative individuals in safeguarding their intellectual property. The primary mission of the Coger Law Firm is to empower content creators and entrepreneurs by helping them establish robust intellectual property portfolios. Karin Coger believes passionately that every creator should have the opportunity to own and control their creative works. This commitment to client education and protection forms the core of the firm's philosophy. Recently, Karin introduced the Brand Protection Blueprint, which is a monthly subscription service designed for entrepreneurs, businesses, and creatives, and e-commerce sellers. I am pleased and honored to have her join me today for this podcast episode. Welcome, Karin. How are you today?
I'm doing great. Thank you, Dr. Dentico.
You're most welcome. I'm really glad you're here because I had myself, when I wrote my own book, Throttle Up, I had to deal with intellectual property issues and making sure that I followed all the rules in using, for example, quotes from other authors. Okay, so I'd like to start off by asking you this particular question. Can you name for me 2 or 3 of the biggest mistakes or oversights content creators make when it comes to protecting their intellectual property?
Absolutely. Number one is content creators build their brands first, a lot of them, prior to doing even a trademark search. So you can file a trademark even before you start using your mark or your logo. So it's important to consult with an attorney, conduct a trademark search, which goes farther than a regular Google search or a business directory search, to see if somebody is already using that same name or brand or logo. A lot of times people put trademarks on the back burner, or they think it's too expensive, but they'll go out and buy a domain name, perhaps inventory for their store, clothing. They invest thousands of dollars into branding and marketing, only to be hit with a cease and desist letter from somebody else that was already using that mark. So that is the number one mistake that people make. Number 2 is not registering copywritten material. First of all, people always ask, what's the difference between a trademark and a copyright? Because they're often confused. So in the most simplest terms, a trademark is your brand and the copyright is for your content. The trademark is for, again, the name of your podcast, the title of your book, the name of your brand, the logo that goes along with it. It helps people identify who you are, who the company is, who the brand is. Copyrights cover written material, audio material, video material. It covers websites and blogs. And so right now, in this era of the digital media, people put out content every day. And a lot of people do not take the extra steps to file for copyright registration for that content.
Interesting. Yeah. I would imagine that is that people just go about their business and maybe not give even a second thought sometimes to the fact that they're creating new stuff and putting it out on the internet when you go to the World Wide Web all over the place. Let me ask you this question as a follow-up. Is there any particular case that stands out in your memory where having had legal intellectual property safeguards would have had a significant impact? By the way, you don't have to mention any names here if you don't want to. Is there something that stands out in your mind that says, had they done this, they would have not been found liable, if you will, for what they had created?
Sure. I will not mention the client's name, but
Right.
the adversary was Entrepreneur Magazine. So just think about it. People talk about being entrepreneurs every day. I'm a self-made entrepreneur. They use the word entrepreneur all the time. And this person in particular did do her research. She looked up the name that she wanted to use, found that it was not in use, filed her trademark, almost got through the entire process. And at the end of the trademark process, there's something that's called being published for opposition,
Right.
where another party has 30 days to say, hey, I oppose this mark. I'm already using it. They're infringing upon my rights. Now, even though she did the research and saw that her mark was available, what also happens is when attorneys do the research for you, they also have access to the information of who is very litigious. Entrepreneurship Magazine was very litigious. They come after a lot of people who use or attempt to use the entrepreneur name in their trademark. So again, this person did her research, but this is the added benefit that working with an attorney helps.
I understand. Let me ask you this question because I'm up against it myself. And that is, what is the length of time associated with a trademark, for example, and copyrighted material?
Sure. For copyright material, it's taking about 4 to 6 months for the registration to process. The trademark, however, it's taking up to 18 months right now. It used to be about a year, but during the pandemic, so many people became entrepreneurs and did do the right thing and file their trademark registrations. So now it's just taking a lot longer.
Oh, that's very interesting. And how long do the registrations last? For what period of time do they cover into the future?
So for trademarks, they will cover up to 5 years. And I'm just putting this basically for your listeners,
Sure.
5 years. But then after that 5 year period, you do need to file paperwork to show that your mark is still in use. Once you do that paperwork, you're pretty much good to go. Copyrights, you're covered for up to 70 years.
Very interesting. 70 years. I did not know that. It's nice to know. I hope you will forgive me, but I can't resist. I just can't resist. The introduction of generative AI, such as ChatGPT, to the marketplace,
Mhm.
looms large over the publishing and intellectual rights landscape.
Yeah.
Do you think enough is being done to safeguard the content creators? And if not, do you have any recommendations as to what should be done?
Although generative AI has been around for a while and it's been coming, technology always outpaces the law. So I do not think that the industries expected the explosion of ChatGPT and the like. So right now, the industries are scrambling. The Copyright Office, the USPTO, the Trademark Office, they're having constant talks. They are trying to come up with some guidelines and some rules. As a member, the bar is trying to come up with guidelines and rules. So for instance, if you go to ChatGPT and have it create a full article for you, do you have to disclose that this was created with AI? Can you file a copyright for that work if that was not your original content? So all of these questions are up in the air. Another issue is not just with ChatGPT, but with the imaging software. I'm a big social media person. I love Facebook. So when a new app comes out and it'll say, hey, upload, 20 of your pictures and we will create you looking like a Disney character or something like that. Now you are uploading your pictures and giving your pictures, to these companies, and nobody reads the terms and conditions except for attorneys like me. So right now, people are playing around with all of these AI tools, not necessarily recognizing the material that they own or the material that they created. They're putting it out there into the world to now be used. And again, I told you a lot of people don't read the terms and conditions. So I can anticipate thousands of lawsuits that we'll see in the near future.
Yeah. What comes to mind immediately is the aftermath, if you will, of the writers' strike in Hollywood. And the notion of chat, I shouldn't say the notion, but the capability of ChatGPT and other generative AI programs was on the table, and how they're going to deal with that as they go into the future.
Absolutely.
I'd love to hear some comments from you about that.
And so it was an issue in both the writer's strike as well as the actor's strike, because with the actor's strike, what studios wanted to do is be able to have an actor come in, be able to take their image, take their voice, and now not have to use that actor and pay that actor in the future when they could just use the image and the voice. So what's interesting is I know that Bruce Willis right now, he is suffering from some issues. I don't know the exact name of the condition, but he does lose some memory. He loses ability to talk. And I was told that he did a lot of movies towards the end, and he is giving a company the rights to his name, image, and likeness to carry on his legacy. However, Samuel L. Jackson said, absolutely not.
That's great. That's an interesting aspect you bring up, name, image, and likeness. You read a lot about that now in the sports world, right. And certainly its impact on the NCAA and those kinds of things. I'd love to hear something from you about that. What's going on in that world, Karin?
Absolutely. So NIL stands for name, image, and likeness, and it has been around prior to the NCAA changing its rules, but now it's just generally used for the student athletes. So prior to 2021, student athletes could not make money off of their name, image, and likeness. They could not even hold second jobs if they were in school and playing for the school. So they were very limited in the money that they were making. However, the schools are out there making a lot of money, up to millions, off of their media rights and off of these student athletes, that they would not be able to have these media rights without them being able to play for them. So now student athletes can go out, they can get endorsement deals, they can get brand sponsorships, they can make appearances, and they can be compensated for it.
Very interesting. It's changed the whole dynamic of college. I'd like to talk to you about your brand protection blueprint. Can you describe for me what you saw in the market as a need and why you developed this new program, and what you expect the benefits will be for someone who signs up for your brand protection blueprint?
Thank you for asking. I'm very excited about the program that is about to launch. So this is a monthly program for content creators and primarily people who produce a lot of content. So like I said earlier, a lot of people fail to file for their trademark registrations because they say, oh, it's so expensive. So if you are a member of this monthly program, if you pay per month, you are allocated time to speak with a member of my office once a month to discuss content that you have created and content that you want to register. And we help you with that. And therefore, having the monthly fee, what you are paying to get this advice. And then on top of that, all you would have to pay are the filing fees with the government. So one of the biggest issues, and the reason why I created this, is a lot of people don't know what content they have to be registered. So for instance, if you are a course creator Let's say you create a course, you upload it to Udemy or one of these other sites, or you sell it on your own on Kajabi. So again, you've created a name for your course, you've created the curriculum, perhaps you've created graphics, created worksheets, workbooks, all of these things need to be registered. And again, in this world of digital media, people are just stealing people's whole courses. So these people are left out here unprotected. And when I talk to them, the number one thing that they said, I didn't know what to register.
Digital technology is wonderful. Can't do or couldn't do what I have done over the course of the last several years. I can't do what I'm doing right now. And I suspect you as well. And it's a wonderful benefit, a wonderful aid, but there's also, if you will, the dark side of it. There's the people who are who create nothing or just want to take from other people. And I agree with you. People have to protect themselves from this kind of marauding, if you will, in the digital workplace. I think it's such a crazy time for, especially in the wake of the pandemic and the explosion of AI onto the marketplace. I think what you're offering is a terrific thing. I think that people like myself would say, hey, listen, I'm not sure if my trademark has run out. I just don't know if it has. And communicating with the government can be tricky, let's put it that way. And it's great. I think it's a great idea. So good luck with it. I really want you to do well with it, and good luck with it. I'm sure it'll do really well. Corinne, let me ask you this as we're getting along here for a few more minutes, and we can expound on this a bit more. My favorite last question is, if you had a magic wand and you could wave it at an issue or a problem in the realm of intellectual property, intellectual rights, which problem, which issue would you choose, and why would you choose that?
Let's see. I think the issue that I would choose is education. In our school system today, the students learn about English and math and science, but this is something that's not taught at a young age, protecting your rights, owning your own businesses. And again, with this digital age, these students are writing, they're putting their content on the internet, they are creating characters, they're creating cartoons. They have so much content out there and have no clue what to do with it. So education for students and their parents, because the students are minors, would be the thing that I would change. And that is something I'm working on as well.
That's great. That's very insightful. It's a profound observation, as I like to say, because we now have young teens who, because of their creativity, are entrepreneurs.
Yes.
They're bringing in money. They've got followers, for example, on YouTube. They're influencers, if you will. So I think, boy, talking about helping young folks get their arms around intellectual property and intellectual rights is just a wonderful introduction, a wonderful way to think about it, and certainly is very well needed. Is there anything else that you would like to chat about, Corinne? Is there anything that you feel passionately about in addition to the education issues?
Entrepreneurship. Entrepreneurship is my other passion. So children entrepreneurship, everybody's not going to be an entrepreneur, but if it's something that you are interested in, I think that people should study it. They should take advantage of the free resources that are out there and go to organizations such as score.org. I have no affiliation with these organizations, but just learn what it takes to start your own business, because it is pretty powerful.
That's great. So correct me if I'm wrong here, but what I'm hearing is you think that maybe in high school or junior high school, maybe we should have a basic course on entrepreneurship.
Yes.
So that people understand what it's all about. What do you think about that?
I think it's great. Now, some of the colleges do have schools of entrepreneurship, but I think starting in junior high and high school would be better.
Yeah, I couldn't agree with you more. In a sense, it's becoming a life skill.
Yes.
That you could start your own business. You could be an influencer, whether it's cosmetics, whether it's fishing. There's so many different things. YouTube just bought the ability of people to put their stuff on YouTube and broadcast is absolutely mind-boggling. In fact, I heard a comment the other day that I think is absolutely true, is this notion of gatekeepers is gone. No one's watching the gate anymore. The gate's wide open. And people are, in fact, young people as well, are, in fact, listening to the drumbeat of their own drum, if you will,
Yes.
and moving down those pathways and creating wealth at a very young age.
Yes.
Listen, Karin, I can't thank you enough for your time here today. I appreciate your honesty, your candidness, and your advice. And I'm sure that my listeners will take away a lot of very important information and give everybody something to think about. Especially, I use LinkedIn. I'm sure LinkedIn and on LinkedIn, and I see content creation every day. Every
Yes.
single day I see it. And so, listen, you've been a great guest. I can't thank you enough for your time and your hard work in trying to safeguard content and intellectual rights for people. Thank you so very much for being with me today.
Thank you for having me.